2 seats available, so it's okay. Under and below. All right, we're going online right now. And we are live. 1 second, it says. So, in this chapter, we're going to talk about public records, which we've spoken about several times. We're going to go more in detail. Title. So we're going to talk about actual closing title and being ready for that, what you need to look out or not. And the actual closing. So you're going to be able to figure out how to ask the buyer to have the money ready and to figure out more or less what the seller should get. Why is this important? Because if you cannot help the seller figure out what they should get, then how can you figure out what they should list for? One of the questions to ask is, what do you need out of this? And they say 200,000, right? In your mind, 200,000 plus the commission, the closings, and all that stuff. Then this is the listing price, right? A lot of people go, "Oh, I want to list for 200,000." Okay, we'll list for 200, and then a closing, 200 minus commission, minus fees, and now they're upset at you because that's not what they wanted. They wanted to clear 200,000. All right, so it's very important you understand these steps and advise your clients accordingly. See, what are you doing, North South? Screwing up the weather.
Change the north and south.
That's it. It's your fault.
This was in Florida this morning.
She just brought it up.
Just brought it up.
All right. Anyway,
They said it's gonna be bad.
don't worry, it's not coming in. It's sealed properly.
So you hope.
So I hope. Hey, they said they did a good construction. I don't know. All right, so again, chapter 21.
She'll the first one to find out.
Either her or Miss Cocaine. They're both at the window. Can you stop screaming? Can you show what? I don't know what that is. Cool. Recording acts. So because we're talking about public records, it's talking about recording documents that are going to be available to the public. Perfect. That's easy. So the state legislature has passed laws that allow owners or parties interested in real estate to record or file in public records all documents affecting their interest in the real estate, to give legal, public, and constructive notice to the world of their interest, right? Now, pay attention to this. It says owners or parties interested. So you're telling me that somebody that's not the owner could file stuff in public records?
Yes.
Of course. Mortgage company, for instance. They're not the owners, but they file a lien against the property, right? What about the oil company in the example in chapter 5 that has the mineral rights, right to drill for oil? Can they file their interest in the property?
Yes.
Absolutely. What about a tenant that has a lease for more than 2 years? Can they record something in public records?
Absolutely.
Absolutely. So not only the owner, but parties of interest or that have interest in the property can ascertain their interest by putting their flag down, right? I don't know if you guys remember, but back in the day, how did you claim something to be yours? The flag. And say, hey, we're here, right? Like the moon, put a flag, you know, because the Russians forgot theirs. That's it. Who was there first? Now, sorry. Yep. Next page. Necessity for recording. Why do we need to record stuff? Now, a deed or mortgage may not be effective as far as later purchases are concerned unless it has been recorded. Because one of the things we do is pull public records to see if there's a title issue, something that needs to be resolved before I can purchase, right? But if there's a mortgage, like, wait a minute, I cannot buy because of the alienation clause. I cannot buy until you clear your mortgage, Mr. Seller or Mrs. Seller, right? But if it's not there, do they have an interest?
No.
No, because it hasn't been recorded. It's going to be a tough fight for the mortgage company. Thus, the public record should reveal the condition of the title, and the purchaser should be able to rely on the search of such public records. from a practical point of view, the recording acts give priority to those interests that are recorded first. Now, all written instruments affecting title to real property may be recorded in the public record of the county in which the real estate is located, which then gives a constructive notice to the world of their existence. So what does that mean? Anybody? What does that mean? Say it again.
It's available for public records.
It's available for public records? That's it?
The key instructions of
So it means it's available for public records.
the county.
Okay.
So we're gonna go online.
So here's the thing. My phone, a pen, and I'm going to write something here. Ready? I'm writing something. You guys know that there's something here. Okay, so I wrote something on my screen. You guys don't know what it is, but you know that is something recorded on my screen. Yes? Now, what I gave to you guys is constructive notice. You know why? Because this right here is going to be right here. This is public records. Everybody can see it's public records available, right? And until one of you gets up and comes see what we have here written, it's constructive. It's available. No excuse. If one of you gets up and comes here, right? Any volunteers? You're going to come all the way from back there. Come on. Come down and get your prize. Game show. I don't know if you can read properly, but don't say it. Can you read? Do you agree? Perfect. Thank you. There you go. All right. So great exercise. So this is what just happened. Miss Cocaine now has what's called. What is it?
Content.
She has content? I hope so. It's called actual notice. We're going to go over this in a second. The fact that she came and inspect the records, she now has actual notice. The fact that the records are available for the rest of you, it's still constructive notice. So let's figure out the difference. First of all, you already know that to be eligible for recording, there must be an acknowledgement. All records must be notarized or acknowledged by a public official. Yes?
Yeah.
Great. Now we're going to go into constructive and actual notice, as I was saying. It says right here, relying on the maxim of caveat emptor, which is let the buyer beware. Caveat is a warning, so beware, right? Caveat emptor, the courts charge the prospective real estate buyer or mortgagee, the lender, with the responsibility of inspecting the property and searching public records to ascertain interest of other parties. Constructive notice assumes that the information is available, therefore the buyer or lender is responsible for learning it. Was the information available, what I had here?
Yes.
Okay. A party of interest, in this case, she came up here because she's a party of interest. She wanted to know what was there, right? Party of interest is the one that needed to step up. I did not have to provide it to you, right? As a seller, do I have to provide it to you? The answer is no. It's in public records already. I provide it to the world. You want to buy this house? You get up and come see it. Good so far? So buyers and lenders are the ones responsible for pulling a title search. Now, constructive notice or what the buyer could find out, is distinguished from actual notice or what the person or the buyer actually knows. Okay? So Virginia right now, she has actual notice. She knows what's here. Do you guys know?
No.
You have constructive. It's still available, but you did not research. So after an individual has searched the public records and inspected the property, he or she has actual notice or knowledge of the information learned. An individual is said to have actual notice of any information of which he or she has direct knowledge. In New Jersey, again, it's just rambles, repeats over and over. In New Jersey, this is so important. It is the duty or obligation of the buyer, purchaser, to investigate the title to the property to be conveyed. The purchaser is held to constructive notice of any outstanding rights on the title that could be discovered by diligent search, including the rights of persons in physical possession of the property. So what I'm saying here is, can you get to the closing table, or even after the closing, go like, oh, I didn't know? Can't. If you did not do the title search, it was on you. If your attorney did not request a title search, it was on you. If your title company did not request a title search, it was on you. If the mortgage company did not, it was on you, because you're the buyer. That's you. My job as a seller was to put it in public records. It's available. Got it? Hold on. Yes.
If the mortgage company accidentally, or I should say technically, whoever is responsible, accidentally forgets to record the mortgage and the property is sold,
That's their
can
problem.
they come back after the seller?
Okay. After the seller is one thing. Can they go against the property? If they did not record the lien, then the lien does not exist. Personal obligation maybe,
Okay.
but the lien doesn't.
Okay.
Remember, there's two documents with every mortgage. You guys remember that?
Yes.
Promissory note and mortgage. Who has priority in the event of foreclosure or sales? Whoever recorded first. If it's not recorded, do they have any priority?
No.
No. Can they go after the person who has the personal obligation? Yes. And then there's bankruptcy. So it sucks for the bank at that point. You got it?
But they
Okay.
can't, the new buyer is not liable for that.
The new buyer is not liable. That's what I was trying to say. Okay? Oh, sorry, Victor, yes.
Excuse me, will this apply to properties in auction?
It's always your job as a buyer to do the research. Auction or not. Okay?
But when it comes down to like inspections and all that kind of stuff, you're not allowed to inspect the house before you buy it, it's an auction, right?
So you're entitled to do your research, your due diligence, but yes, auctions are sight unseen. Unless you have a sudden urge to go to the bathroom, that's the closest bathroom. I knocked on 20 doors, nobody's opening, please.
You can do title search.
No, but he's talking about the inspection, like seeing the actual property, that you can't. But title search, you have to.
You
Or
should
should.
title search. I mean, there's a notice up there, like a month ahead or something. Like it's public, that, this property is gonna go on auction, so you'll hire a title company to do the title search for you. And before you go and offer it.
Yeah, they're simplified searches, and especially for auctions, you don't have to go too complicated. Because it's not an actual closing, so you're not looking at the background of seller and outstanding rights that could come after the property. There, it's clean, right? It's just what it exists.
Yeah, but seeing the property.
But seeing the property, get creative without doing any type of B&E, but get creative.
See property, look at the list, see what they say you may owe.
I'm sorry?
Buy your
Look at the
drone
list and
and
see what
fly
they say
around
you
the
may
house,
owe.
record inside.
Oh, is that, they just use the back door? I didn't say that. Did I?
Or get a pocket drone.
Yeah.
Imagine the little tiny ones, the flies that they use in the military. Into the house. Oh, looks good. Get out. Don't do that. All right, next. Recording sales contracts.
Play the inspector. Look,
That's it.
look.
You go in. City inspector.
That's it.
guy opens the door.
I did
don't do
that.
anymore.
I did that once.
Don't say that. We're live.
It's okay.
I impersonated a public
No name,
official.
no name. Oh, no, come on. Now you said my name.
I didn't say, she said it. Okay. So whoever's watching from home and people here, do not impersonate public officials. Very wrong. A lot of trouble. I did that once. Thought I was bad. All right. Chain of title. Question. What is a chain?
Something with links.
Something with links. A chain is composed of links. Absolutely. So, if there's a link missing, do we have a chain?
No, it's broken.
It's a broken chain. Very important. So, the chain of title shows a record of ownership of the property over a period of time. An abstract of title is a condensed history of all instruments affecting a parcel of land, particular parcel of land. Through the chain of title, the ownership of the property can be traced from its origin to its present owner. If this cannot be done, it is said that there is a gap in the chain or broken chain. And a quitclaim deed is commonly used to bridge such gaps. I'm not going to go in detail here. Go to the next page. And it says right here, evidence of title. Can anybody tell me which document or documents will give you evidence of title?
That'd be the deed.
The deed? Anybody else? The recorded deed?
Title insurance policy.
Okay.
Certificate of
So
title.
let me just thank you for reading.
Yeah.
Let's address the deed. In green it says,
Deed is not proof of title.
oh, deed is not proof of title. See, I always ask the question because I know the answer. I know what you guys are going to say. Everybody thinks the deed proves title. No. See, the deed proves that the transfer occurred, but it does not prove that there was good title in the first place. A deed is just a document that says grantor, grantee, here's a property. You got it? For you to know and have evidence of title, you need to track the previous owners. How do you do that? Through the abstract of title, title insurance policy, torn certificate, or certificate of title. Okay? These are the only 4 ways to get evidence of title. And there's flaws in it as well. Okay? So let's figure this out. Abstract of title and attorney's opinion. First thing is, what is an abstract? On top of abstract, you guys are going to write summary. Summary. Abstract, we're going to write summary. For you to think of brief history or condensed history of events. An abstract is we pull all the information, and instead of giving you a detailed report, we give you a summary of that information. Okay? So, it says right here, a brief history of the instruments appearing in the county record that affect title to the parcel in question. It is necessary for each section of the abstract to begin with a search from the public record from a date immediately following the date of the previous section. I'm sorry. So simply, I own this property, right? I own this property from December 1st until now, and I'm selling it now. Who owned it before me? Well, it has to be from November. What's before December 1st? Great, so December 2nd. That means the previous owners from December 1st until whatever they purchased. Okay? The months are confusing, I know. So, too early? It's not lunchtime yet? Okay. So they own it from December 1st till, from April till December 1st, right? So April 5th. The one before that owned from, let's say, 2016, let's say January 3rd until April 4th. So you got to make sure that it's immediately proceeding. if there's a gap, meaning like a month or two or a year or two, then somebody did not record. And if you guys remember from yesterday, a deed does not have to be recorded, right? But in this case, if we want to prove that you're the owner, evidence of title, right? Should you record your interest? Absolutely.
But you also said that you didn't have to be dated, so.
Dated or recorded. But once it goes into public records, you'll go with the date that the transfer occurred. So if I got it today, the deed today, when I go to public records, I'll put the effective date of the deed, which was today. Can I go to public records tomorrow
Yes.
and I'll say that it was today? Yes. Can I go a month from now and say that it was today?
Okay.
Yes.
I get it now.
Okay? So we're filing today something that's effective back in whatever date. Yes. Can you stop yelling, please? Anyway. You guys good with this? All right. So if this was not done, there will be a gap in the abstract. Now, when an abstract is first prepared or it's continued, the abstractor lists and summarizes each instrument in chronological order, along with information relative to taxes, judgments, special assessments, and the like. Now, an abstractor is just somebody that's pulling records. It's very important you know, an abstractor is just somebody pulling records, putting them in order, and creating that summary. The abstractor is going to conclude with a certificate indicating which records were examined and when, and then he or she signs the abstractor. And like I said, they just pull records, right? So, an abstractor does not pass judgment or guarantee the condition of the title. I'm just pulling information. That's what I'm saying. And I'll tell you, I pulled information from these sites, from these locations, these records. You guys got it? I don't know if this title is good. I don't know if this title is bad. I just pulled info. Who's going to analyze the information? If it's abstract of title and attorney opinion, then who's going to analyze the information? An attorney. Question on the words? Dante? Question on the word?
Yeah, no, I was just trying to figure out the difference between title and deed.
Deed is a document that transfers. Title is showing a track record of transfers.
Okay.
Okay, so deed is a document that transfers. So today if I sell something to you, it's through the deed, that document. Does it prove that we have good title?
No.
No, because you have to see if before me, somebody transferred to me.
So would it be simple to say that the title is the history of how the house was transferred?
That's what it is, evidence of title.
Plain,
So-
simple English.
Yep. Perfect. All right, so every time you have questions with words, try to, or whatever, try to go at me first. If not, I'll point it out to these things. I noticed you're going like, what's going on here? You guys got it? Plus, you're not the only one with that question. It's just others are not asking. Okay? And you didn't ask either, I asked. Now, so attorneys, they're the ones that review what the abstractor pulled out. Okay? Now, an attorney is going to analyze or examine the entire abstract. Following his or her the detailed examination, the attorney must evaluate all the facts and material to prepare a written report for the purchaser. On the condition of the ownership. And this report is called Attorney's Opinion of Title. So after examining all these records, right, this is still not title. After examining all these records, the report is now saying there is a good title, there is a good, it's like you going to school, right, and they give you a transcript of what you did in school. It's almost the same thing. You could pass or you could fail, but I want to see your transcript and see what happened. You got it? I can have a diploma. Well, show me how you got the diploma. Was it on one of those websites, or do we have a transcript? You got it? In case you guys don't know, you know the website. Okay. He's like, I know. We had a deal.
I know. I already had enough coffee.
Yawners, tell you. She said before the class started, "Ooh, this is good coffee, so I'm not gonna fall asleep." And here she goes opening her mouth. And we're not even, see, Victor's smart, look at that.
Look at them.
13 of us, thank you.
I don't drink coffee.
It's a joke. He's in the Navy, he's not gonna do this. All right. So attorney's opinion title, abstract of title and attorney's opinion title is one of the ways for evidence of title, but it's not as used as extensively as in the past. And the reason being is very simple, because every time I give a legal opinion, it's different from giving my opinion as an individual. Because if I tell you guys, as an individual, not as a professional, as an individual, I'll tell you guys, it is my opinion that it's still gonna rain today, right? It could or it could not. It's Jersey. We never know, right? It's an opinion. Can you sue me for telling you it might rain today?
No.
No, you can try. Well, and given the conditions of this country, you might win. So you can try to sue me. But if it's
Condition of the state.
country,
State,
because,
especially the state.
well, the state as well, but this country is amazing for lawsuits.
Yep.
A hot fry or a hot coffee that you spilled over you while driving and doing makeup and on the phone and whatever, and you still win the lawsuit because the coffee was too hot.
$1 million, right? Or was it like
No, it's more than that,
2.6?
right? Or the lawsuit about fast food making you fat.
Yep. Mm-hmm.
And now every single fast food place must have all the grams of whatever is included, every single item that's included in that sandwich.
There's a lawsuit now that
So this country.
the guy is suing this NFL for $800-something trillion because
Trillion?
because he thinks he's going to hell for watching the halftime show.
Really?
Yeah, I heard it this morning.
Yeah, I read that.
All about Shakira, man.
Yeah, for watching Shakira and J-Lo. He thinks he's going to hell for suing the NFL.
I didn't watch it, but can't blame him. Now, next.
He might win.
This was a guy?
This is my class action suit. Everybody about to fall in.
No, but this was a guy
Yeah.
complaining?
Yeah. I didn't watch it, so I have no idea
$800 trillion.
No, because I heard of some women complaining about the halftime show, how it was.
Right.
But last year, when it was Adam Levine, they were like, oh my God. And they got to call for shirt, nobody complains.
It was the best halftime show
This one or last year?
this year.
Okay. Hey, to each his own. Right. Anyway,
Boys,
Teachers, it's your fault. Before you continue. For,
is this still about the NFL?
yes, no, it's about time.
Okay.
So you getting back on topic.
I'm back on topic. I was just gonna.
With the attorney's opinion,
Mm-hmm.
what about the ones that don't use attorneys? Like states that don't use attorneys, when the title company just do the title work?
We're getting there.
Okay. Go ahead.
There's 4. We did 1. Thank you. So, I said that attorney's opinion is not used as extensively as in the past because when I give my legal professional opinion, what can you do? You cannot sue me because of telling that it's going to rain, but if I tell you, hey, in my professional opinion, legal opinion, because I'm an attorney in this scenario, right? My legal opinion, title appears to be good. What if it's not? What can you do? Right, you can sue me. Now, every time there's a chance of a lawsuit, they create something called insurance. Like the first car that started driving on the road, did they have insurance?
No.
No, but after the first, second, third, or fourth accident, they're like, maybe, just maybe, we should have auto insurance. Does this make sense? So now we have auto insurance. In this case, after a few lawsuits regarding title and the opinions, they created something called title insurance. And that's what we here in New Jersey rely on, title insurance. So it doesn't mean that the title is good, it means that it appears to be good, but just in case, let's insure the title. Because if anything is off of what we saw, at least we're protected. You guys got it? Great. So A buyer or seller seeking to obtain a title insurance policy as evidence of ownership makes an application to the title insurance company. The company examines the title records and agrees to insure against certain undiscovered defects. So it's not the attorney examining the records, it's the insurance company underwriting the records. You guys remember underwriting? Risk assessment. Okay. So exactly which defects the company insures against depends on the type of policy that it will issue. A policy usually insures against defects that may be found in public records, such as, check this out, forged documents, documents of incompetent grantors, incorrect marital statements. I'm single, this is my house. And all of a sudden, they're not single, they're married. So it changes. And improperly delivered deeds. Okay, so it protects you, the buyer, against any of these mistakes or fraud perpetrated by the seller. Got it? Yes?
This is mandatory, like, you have to have it.
You have to have title insurance? You have to have liability in your car?
Yeah.
Great. So, if there's is it mandatory? I'm going to put it this way. Who forces you, when you have a car, who forces you to have coverage?
DMV, state,
Liability. What about full coverage?
whoever owns the car, the bank.
The bank.
Yeah.
So because there's financing involved, the bank will say
You gotta have
full coverage. In this case, a mortgage company will most likely not close until you have title insurance.
Okay.
As an individual, if you buy cash, do you have to have title insurance?
No.
You don't have to. Should you?
Yes, you should.
Got it? So it's not a law that mandates, but depending on how the purchase is being conducted, you might be required to buy one of the parties. Now, on completion of the examination, the title company usually issues a report of title or a commitment to issue a title policy. An owner's policy excludes coverage against the following exceptions: unrecorded documents, unrecorded defects of which the policyholder has knowledge, rights of parties in possession, and facts discoverable by survey. So they exclude this from the coverage. So if any of these happens, it's on you. The title insurance company agrees to defend the title at its own expense and to reimburse the policyholder up to the amount of the policy for damages sustained by any reason or defect not accepted. Now, there's different types of title policies. We have the mortgage title insurance policy, we have the owner's title insurance policy, and we have the leasehold title insurance policy. So yes, as a tenant, you can also protect your interest in that title. You know why? Because I'm renting from the owner, but is the owner the owner? Does that make sense? Obviously, residential tenants don't do this, right? Just the cost doesn't make sense. But if it's a commercial tenant, they want to protect their interest. It's a long-term lease. It's hefty lease, so they want to protect themselves. Next, I have it in green, and it makes sense that a mortgage title insurance policy insures a lender that it has a valid first lien against the property. Yes? Great. Now, a title policy required by lenders insures the lender's interest but does not protect the owner, and it's always only for the remaining amount due on the mortgage. So if there's a title insurance policy that's a mortgage title insurance, protects the lender for the remaining of the loan. Okay? New Jersey law requires lenders to inform borrowers of this fact. Homeowners, raise your hand again. At closing or before closing, did you get this notice? Because it's required. Did you get this notice that says title policy, this title policy that you're purchasing protects the lender, not you?
Nobody explained it, but it's in there.
Say louder.
Nobody explained it, but it's in there.
Nobody explained it to you, but it's there. See, it says here, they're required to inform, they're not required to explain.
Even that, they didn't only say it.
I'm sorry?
They don't only say it.
Did you sign it? You were informed. Did you read it?
No.
That's your problem. You see what I'm saying? It's in that package of, well, now they're required, as of October 3rd, 2015, when you're at the closing, they have to explain all the documents to you. The title company that I work with sits down with you, explains every single document. This is what it says. If you have any questions, let me know. Next page. This is what it says. That we're going to do this, we're going to do that, or the bank's going to do this, or it's going to do that. They explain every single detail of that closing. Does that make sense? They have to. This, you guys signed or initialed, and it's a one-pager that says, it's like a cover page to the title policy. And it says, this mortgage title insurance policy protects the lender, does not protect the borrower. But you can, for additional charge, also purchase your own. Simple. You guys got it? It is a one-pager, very simple, easy to read, but because you're tired of all the paperwork, you skip it all. Yes?
This applies to any type of loan, like FHA, conventional, or VA.
What applies to it?
The
The mortgage title insurance policy is always for the mortgage and for the balance of the mortgage and to protect lenders. The mortgage is financing, and financing could be any of those situations. So yes, if you have a VA loan, there's a protection to the mortgage company because a VA loan is not given by the VA, it's given by the bank. So the bank is protected.
Okay.
What you need to figure out is if you paid for an owner's policy. Because if you do not pay for an owner's policy, they are protected, not you. So if the seller committed fraud or somebody before the seller committed fraud, the previous owner, you could lose your property, the bank gets paid, and you have nothing. Nothing.
Yeah, I just wanted a real life example about this, because I'm not getting it. So let's say there was fraud on the title. Not the person who's selling it to you, but a previous owner.
Okay.
Do you have the insurance?
But you don't have the insurance, the lender does.
Okay.
Could
The,
have.
you could apply. Do you lose the property?
Okay, so let me ask
Yeah.
you this. If you don't have insurance, right? And I come up to you and say, hey, Duncan, this is my property. What are you doing here? And you go, I have a deed. Well, who sold it to you? Well, it says it's this person called Bruno. Well, did you see me? So it's forgery. Give me my property back. I'm going to sue you to get my property back. Good so far?
Mm-hmm.
If you have insurance, then you're going to activate your insurance, and my attorney and the insurance attorney are going to talk, and the insurance is going to pay me off or pay your lender. And you're screwed if you don't have your own policy. If you have your own policy, then it's going to protect you as well. Either you get money or you keep the property. And I either get money or I get the property back. It's one or the other. That's why you have the insurance, to protect your interests.
So-
Obviously, you want to keep the property. So somebody's going to have to get compensated. Okay? If you don't have insurance, if you personally, as a homeowner, don't have insurance, are you protected?
No,
So you could lose your property.
without knowing.
Well, you will know because there's going to be a lawsuit.
I mean, without knowing that somebody had a claim to
Oh, yeah.
the property. So it could be one of those, so-and-so had a lifetime on the property. He gave you the property until you died, and it reverts back to him. But it kept selling,
Well, it could.
yeah?
It could, but you should have seen the deed that says that. What I was talking about is somebody committed fraud. Like, for instance, there's a lot of John Smiths out there. The most common name in the United States, John Smith, right? Right next to Gonzalez. Now, what I was trying to say is very simple. John Smith, if you guys remember from, what do you call it? If you guys remember from yesterday, the deed must be signed by the
So,
seller, the grantor. Yes? So if a John Smith bought the property, do we have John Smith's signature?
No.
No. Do you have John Smith's date of birth? Do you have the social?
No.
Do you have an ID?
No.
You have absolutely nothing on which John Smith it is. In fact, and look, I'm not talking bad about the country itself, right? But in this scenario, we're so worried about fraud in this country, right? And I always talk about this in my classes. So worried about fraud, but in the United States, you can only be John A. Smith. Could be John Allen, could be John Adams, could be John a bunch of things. You see what I'm trying to say?
Yeah.
So technically, if I'm a John Smith, you know what? Scratch that. I'm going to go to Chinatown and get a fake ID saying that I'm John Smith. There's no pictures, there's no date of birth, there's no signature. Nobody knows if I'm the real one or not. I'm going to go search public records for a John Smith. And I see a property on 18 Oliver Street as an example. And now I'm going to put it for sale. I'm John Smith, based on my ID, and I'm selling it to you. How are you going to prove that I'm not the real John Smith? You see what I'm saying? So forgery is one of the things that's protected. We just went over this, right? Right there, forged documents. Forgery. So if I sold you somebody else's property, right, pretending to be that owner, and you don't have any insurance, I made my money, and you lose your property. The bank will get paid what they need to get paid. How about an improperly delivered deed? It says right there. So it's correct as well. Like a grandfather gives the property to a grandson, but then forgets to actually give it to him or record it or whatever. The grandson finds the deed. Can they come up and try to claim it?
Yes.
They can try. And if you don't have insurance, what happens to you?
You're out.
So these are the types of scenarios that we're talking about.
Okay.
The life estate is a little different because it's recorded. It's part of the deed. We're talking about stuff that it's not listed. Because if something is part of the deed, the insurance company will not even protect you. So something that could be discoverable by survey, something that is noticeable, right? If it's part of the deed, they don't cover. You got it?
Yeah.
All right. All right. Next, Torrance certificate. In some other states, it's cocaine.
Yes.
In some other states, the Torrance system of land registration is used to prove title. The good news and what you need to know for state exam,
Doesn't work either.
not used in New Jersey. Yes? Great. So if there's a question that says, all of these could be evidence of title in New Jersey except, there's four. There's abstract of title, attorney's opinion. There's title insurance, Torrance certificate, and certificate of title. So there's four exact answers for this question. All of these could be evidence of title in New Jersey except. That's the answer. Do not write state exam answer, okay? Just put stars. And then the next one, certificate of title, is exactly the same thing as abstract of title and attorney's opinion, minus the abstract. What does that mean? It means we're not pulling any records. It's just the attorney saying, yep, you're good. That's crazy, isn't it? Where do we find these?
Crazy states.
No. Look the very first sentence. What does it say? Yep. Especially farmland. Farmland traditionally is passed down from generation to generation to generation. So how are you going to prove, right, that that person is not the owner? It's very difficult. Especially because even in Jersey, some of these towns don't have records yet. Some of the stuff is not on record yet. You guys got it? Even in Jersey. Tiny state, but some places still don't have an actual registrar. Okay? So a lawyer's opinion of title is often oral, not even written. Oral or implied representation. So I just said, Victor, you're good. You can sell or you can buy. Title is awesome. Right? So what does it say? A person who sustains damages by relying on it can look to the lawyer for satisfaction. You guys have any questions? No? Great. We have something now called marketable title. Marketable title. Who can tell me what is something that's marketable? That can be?
So,
They can be sold or exchanged. Something that could be put on a market where buyers and sellers would be interested, right? So, marketable is something that can be sold. So, in my examples, I like to talk about milk. What you laughing at?
He gives nice for everything. It's Dora, it's milk.
Yeah, listen, it works. Milk. So, who still buys milk?
I bought milk.
Okay, great. Some of you don't. Okay, great. But you buy milk. So if you still buy milk, there's one thing that everybody does, well, they think they do. Excuse me. There's one thing that everybody does or they think they do, but they're incorrect. Okay, so I'm going to tell you right now you're incorrect before we start. So when you buy milk, what is the first thing you look at?
Expiration date.
Wrong. I told you it was going to be wrong. Didn't I? Didn't I say that?
Price.
Okay, we'll go with price. Okay,
the brand.
the brand. Okay, and what else?
The label, guarantee label.
The guarantee label.
That would be the expiration date.
Well, I think there's a label that says approved by US.
Unless you were there and watching that cow, there's no guarantee. You know what I'm saying? It's like I love when we go to a restaurant like certified Angus steak. Like where's Angus? I didn't see him. No, but I know what you're saying. The USDA, organic thingy.
But it's
We got it. Type of milk, price, brand. Got it. What else?
It's closed or open. Leaking or not leaking.
Listen.
Check.
You guys know that there was this lady opening ice creams, licking them, and closing them, right? It was on the news. So I agree with that. Check always to see if it's open or closed. But let me go back to what they said first. Expiration date. And here's my answer. Milk does not expire.
what kind of milk you drink.
No milk expires. In fact, it says best if used by. Doesn't say expiration date. Does not expire. You know why? Because milk does not expire, it transforms. From milk, you have other things. Yogurt, cheese, butter. So as soon as the milk rottens, what can we do?
Yogurt,
The good stuff for your system, right? Just want to put out there. What I'm trying to say with marketable title is, most of you will never buy milk after that so-called expiration date, correct? All right. So you want the milk to be marketable. You want the milk to be ideal, yes?
Yes.
But some people are crazy. Some people go to every supermarket they can and say, hey, as soon as it expires, I'll buy all your inventory. Why? Because you're going to throw it out anyway. So instead of $4 or $5 per gallon of milk, I'll buy it for $1 or less. So they buy a discount. Does this make sense? As far as marketable title, most people want a marketable title, one that is so free from significant defects. Look what it says in green. Other than those that we agreed to, right? That the purchaser cannot be assured against having to defend the title. So there are some people that want to buy a property with issues, whether it's title or property defects, right? People will, but the majority of your clients, They want what's called turnkey properties, meaning, don't give me any headaches. I want the house that already has everything I need and easy to transfer title. Okay, so that's 90% of your clients. 10% is the crazy people that really don't care. That's the green thing right here. Crazy people that really don't care. The more problems, the better it is for me. Bring me those properties. You guys got it? Yes? So, right next to marketable title, I want you guys to write rotten or expired milk. Expired milk.
I remember you in my state exam.
You're going to remember.
Exactly. I think about you, of course. Wow. Because I will pass.
You will pass, of
Yes,
course.
of course.
Absolutely. Is there any doubt? You will pass.
Yes, of course.
That's it. It's done. She's going to be in the middle of the exam. Dora! Milk!
Can you picture a person who's watching the video and just hearing her go through all this? Like,
That's what I'm saying. It'll be awesome. I would love to record it.
Or squirrels.
Whenever you go, let me know so I talk to the proctor.
Miles an hour.
The squirrels 35 and 60 miles an hour. I just want to be there that day when you guys take the exam and just listen to you. I'll have somebody watch, but I'll just listen. Not bad. All right. I have to make this chapter fun because I'm telling you, if all the other chapters were boring, this one is very, very boring.
it is.
Very. Anyway, closing the transaction. It gets a little bit more exciting. We're closing, right? It's not that exciting. Now, although, check this out, salespeople are not burdened with the technicalities of closing, meaning it's not you that's going to close, right? They must clearly understand what takes place. A real estate specialist, who are the specialists? You guys, you're special, we know this, should be able to assist in pre-closing arrangements and advise the parties in estimating their expenses and the approximate amounts that the buyer needs and that the seller will receive at closing. I said this right in the beginning of the chapter, didn't I?
Yes.
Great. So, things to know. In many sales transactions, two closings actually take place. In many sales transactions, two closings actually take place. Because most real estate transactions have a mortgage involved, two closings actually take place. We cannot close until this one happens, which is closing the buyer's loan. So until the money comes from the lender to the escrow account, right? Until the money is transferred from the lender to the escrow account, do we have it clear to close?
No.
No. So the closing, the actual closing, only happens after the money is there. If it's a cash transaction, we only have one closing. If it's financed, there's two closings happening at the same time. The loan and the actual sale. Questions on this? Great. Because here's what happens. The buyer wants to be sure that the seller is delivering good title and the property is in the promised condition. Yes? The seller wants to be sure that the buyer has obtained the stipulated financing and has sufficient funds to complete the sale. I'm not going through the whole thing because I'm going straight to the common sense. Right? Buyer wants the house to be the way it is, and seller wants to make sure buyer has money. And obviously, when the parties are satisfied that everything is in order, the exchange is made and all pertinent documents are then recorded. Simple. Closing. See, real estate is so simple. So easy. But what did I tell you the other day that the biggest variable was when we talk about investments? People. Real estate is very easy. Everybody should be able to close in 2 to 3 weeks. But no. Nobody listens to what we need to do. For instance, I'm just going to give you a quick heads up of things that could be done prior to even having a buyer. A CO is valid for 6 months. At time of listing, you have a listing for 6 months. Why not request the seller to get a CO right away?
Yep.
No, let's wait until we have an offer, then go for the CO once everything's cleared. I'm just saying, are you gonna sell or you're not gonna sell? Just to give you an idea. How about doing an inspection, a pre-inspection of the property? Mr. and Mrs. Seller, let's find out ahead of time, if there's any issues that might be brought up once we have a buyer. Anything that could delay the transaction. Why not? Let's pull the title to make sure there's no surprises. It's only like $100, pull the title. Make sure there's no surprises, because this happened to me in a property that we were going to foreclosing, and there's a $13,000 judgment against the property. And I'm like, I didn't know about this. And we did not close until we corrected that title. $13,000 belonged to the previous owner, and it was on a general judgment. It's not even against the property, so that was cleared real quick. Right, are you guys understanding this? Surprises, just like your credit report. Shouldn't you check your credit report constantly?
Yes.
Because sometimes they put something against the wrong John Smith.
Yep.
You see my point? So, Mr. and Mrs. Seller, you want to sell in the next 2 weeks or 3 weeks? This is what we need to do. Get everything done prior to listing. Also, if you do an inspection before, and there's leaks, there's mold, there's whatever, now you know that instead of $300,000, you're listing for $260,000, $40,000 less because there's damages. Say it again?
Nothing. You don't hear it.
I didn't hear you.
It's online.
Yeah, you can say it. I mean, impersonating a public officer. So, what was yours?
Over the mold.
You paint over the mold. There you go.
Did you bleach it first?
Yes.
Yeah, because of the.
You just say to do all that before you put the listing on the market?
Yeah, why not?
Or during, or after?
Prior, during, but don't wait until you have an offer.
Well, the CO, I don't really agree with that.
That's fine. You don't have to. I'm just giving you my opinion because it's 6 months.
The home inspection, yes. The title, yes.
But a CO is 6 months. What's the
The
issue?
appraisal, private appraisal, yes.
But why not the CO? Tell me why.
Because depending on the town, some towns that don't give you the 6 months, they give it 3, they give you, some they give a year. I don't know.
How long is your listing? My point was this. No, my point was this.
The CO is pretty obvious. I mean, you experience a real estate agent, you know the regulations of the town. So you go on the website and you find out. And they tell the owner, you have to do this, that, and that to pass. If you don't, guess what? They're not gonna pass.
Perfect. No,
But when
I
it
got
comes
you.
to home inspections, I agree. Behind those walls, there's a lot of stuff.
All right, so you just said something that's very important. You know the town. The problem is the majority of the realtors, especially in the beginning, they try to grab business everywhere. So how many towns do you need to know what's needed or not needed? Some towns it's not even needed.
The one you're gonna list.
So my advice is always to find a market, focus on that market, and you always make money. You're trying to grab business all over the New Jersey, you'll make no money. You'll spend a lot of money in gas, mileage, maintenance, and no sales. Because you cannot make it to the appointments. You're wasting time. So get to know 1 or 2 towns, and that's your market. Know their rules, regulations, and the CO is 3 weeks anyway, so you should be in enough time to do it. But my point with having everything before is because traditionally it is a 6-month CO, and if you have a 6-month listing, my question is, are you going to sell or not?
Yes.
Because if you doubt your own listing,
No.
then why did you take it? That was my point behind it. There's a reason why I say whatever you need to do during the transaction, why not try to do as much as you can before? And then by the time you get to it, it's already done. Now, as far as the title search, title are independent third parties. You cannot force the buyer to use your title company, but if the report is done, it's provided to the attorneys, and if they choose, then half of the work is already done.
Right.
Speed up.
So you can do the home inspection, same thing.
Same thing. It's third parties, independent. Do you have to use the home inspector that I just used? No. But why not?
Paid
Right?
for.
It's paid for.
We found problems, we correct the problems.
What the thing they see it is, absolutely, the thing they see is, well, you pay the home inspector to come up with that good report. That's what they might say, the buyers, right? But the majority of them, hey, they're certified, they're bonded, they're insured. If anything goes wrong, you can blame the inspector. Are you seeing what I'm saying here? Yeah. How do you think there's this big billboard every 5 minutes that you're driving that says Rob sells Jersey, guaranteed, right? Because he has a list of stuff that you should do, a pre-listing list. And some of them even say they're crazy to say. This is very important for this chapter. You want to close, you have to be ready for all this stuff, the contingencies. Some of them even say, I'll get your home sold within X amount of days, or I'll buy it. But then there's conditions. This is provided that you follow my checklist. You missed the checklist. Am I liable for buying your property? No. Anybody can do that. You guys got it?
But you can buy it for the price.
No. You can buy it for the price, but the point is there's always the escape clause. That's what it was. It's like once you sit down. So years ago when I started in real estate, we used to rent with option to buy, and the marketing that we were doing was very simple. I'll get your house sold in 7 days. That was the marketing on Craigslist. I get your house sold in 7 days. Now, who wouldn't want to have a house sold in 7 days? Right? So that would attract people. And then here comes the conditions. How am I going to get your house sold? I'm going to get somebody to rent with an option to buy in the future. You'll make more money this way, and somebody pays your mortgage over the next period of time. If they agree to it, your house is sold within 7 days. If they don't agree with it, I don't have to buy it. This was my plan. You guys got it? Come up with your own, as long as it's legal, certain conditions, you're good to go. Or buy it at a very steep discount.
Money talks.
And we're going to keep it there. We won't say the rest. All right. 12:30. We're good. All right. Lender's interest in closing. This we're going to skip. It's common sense. I mean, skip, meaning you're just going to mark the bullet points. It's common sense. You got to have the title insurance, homeowners insurance, inspection, CO if required. We just talked about it. Reserves for escrow for tax insurance. And of course, their own attorney representing at closing.
So you just gave a list of things that you can do to help the seller be able to be ready to close on their end in a reasonable amount of time. It's not what New Jersey gives us 3 months. But anyway, but the buyer, what would be some suggestions you would have on that?
Pre-approval. That's the only thing the buyer needs.
Correct.
What else does the buyer need to do? If the inspections are done, if the title is done, what else does the buyer need to do? Because the mortgage company, all they're waiting for is the inspection, the appraisal, and the title. The seller just needs to list and get the CO, and that's it. The buyer needs to do inspections and all that. So if we did everything prior, could you technically close in less than a month?
Yes.
Absolutely. How many people will go for that?
A lot.
No, because sellers don't want to spend money.
There's ways around that.
No. Listen, the biggest issue you guys are going to have in what I told you right now, that's guaranteed, if they follow this, is guaranteed to close in less than a month, right? But the problem you're going to have with this is that you're telling the seller, hey, you're about to sell your house, but spend $500 on the inspection. You're about to sell your house, spend $100 on title. You see what I'm saying? Get the CO, $250. You're telling them to upfront, before even listing, to get these items. They don't want to spend money. That's why they hired you. That doesn't charge anything until closing. You guys understand? That's the biggest challenge. So you have to try to go around and explain why they need to do it first. But that's up to your broker to train you. New Jersey requirements, everybody knows already from Chapter 9 and from Chapter 18 that before the closing on any 1 or 2 family house, the local government must certify that the building contains at least 1 properly installed carbon monoxide detector, as well as smoke alarms and fire extinguisher. Yes? Great. If it's in a flood zone, you need flood insurance. Great. RESPA. Does anybody remember RESPA?
Yes.
Okay. I'm glad you remember. Who can tell me what it is? What is it?
A test.
It's a test.
It's a document that shows all settlement costs.
Yes. Put a box around it and highlight the green stuff. It's a document that shows all the settlement costs. That means the cost to close in the purchase of residential property. Things to remember. It's for the purchase of residential property. That's what I have in green. Purchase only. Yes.
No, you're saying, I think
You're
you said-
just retaining info. I see you take notes and I'm like,
I think you said in the beginning that we should be able to tell the seller how much money is gonna walk away.
Yeah.
After the close.
Mhm.
Are we gonna get to that point
Yes.
yet, or?
Cool. But it's easy. You can estimate the closing costs. You should know by now from enough transactions to estimate the closing costs for a particular value, right? Minus the commission, how much do they walk away with? Minus the mortgage, if they have one.
Now you have the transfer, we just say transfer.
Closing costs. But you should be able to estimate it's anywhere between 2.5 to 2.7% of the transaction is the closing costs. So, Mr. and Mrs. Seller, $100,000 minus 6% commission minus 2.5, or let's make it, you can make it 3% if you want. So it's better to under promise, over deliver, right? Right? So minus that, minus whatever you have to pay the bank, this is how much you take home, more or less. If that does not meet what you need, should we even list it? If the property, they want a 300,000, the property's worth 280 plus your commission, forget it. We're not going to be able to sell this. So things you need to calculate. Anyway, right here at the bottom, RESPA regulations apply only to transactions involving new first mortgage loans. New first mortgage loans. Next, on top. Now, when a transaction is covered by RESPA, the following requirements must be met. It starts with Section 8. Now, this is not the Section 8 housing. This is Section 8 of RESPA rules and regulations. You got it? So, under Section 8 of RESPA, it says you cannot get any kickbacks. What is kickback? I refer business to you as another professional, and I get money for referring the business. Illegal. There's a lot of mortgage companies that will tell you, refer everything to me and I'll give you X amount of dollars for every deal. Or you are the one that attempts to get that deal from the mortgage company. Illegal. Explicitly, if you don't know explicitly means don't do it, explicitly prohibits payment of kickbacks. Okay? The only way to legally earn money is if you're licensed in that position as well. And then you did what's called a referral. And even then, there has to be a disclosure to the buyers that there's a proposed business transaction that would affect them, okay? So be very careful when you get a kickback. It's the same thing as getting paid for referring somebody, okay? Don't do it. There's other ways, there are legal ways of getting some type of compensation as long as it's not related to the transaction. Like marketing. Mortgage companies can contribute, for instance, up to 50% of your marketing. I mentioned this in mortgages. That's okay. But it cannot be, oh, here's a lead, right? Now give me X amount of dollars. Can't do that. It could be an ongoing, what's called MSA agreement. So it's an ongoing agreement to compensate for certain things in your office, contribution to certain things in your office. Again, up to 50%. No problem. And that's with your broker, not with you. You guys understand what I'm saying? These are laws.
That's like because you told them, I give you a referral, so how much you would give me?
Yeah. That will be a finder fee, and no, illegal. But very similar to that. Section 9 also prohibits lenders and sellers from requiring that the buyers use a particular title insurance provider. I just mentioned that. Just because I do title search doesn't mean you have to use my company. Okay? Cannot force you. Section 10, lenders are not required to maintain escrow accounts. However, if the lender does require an escrow account, which most do, right? RESPA limits, and we're not going to talk about limits here, but limits the amount that they can charge for that. So usually what they do is ask you, hey, there's the taxes are $12,000, give me 3 months. So $3,000 into escrow, as an example. But they cannot charge you the whole year. You guys got it?
Mhm.
So you have to show these reserves, and they cannot, there's a limit on how much they can charge. Does anybody remember this? TILA, RESPA integrated disclosures? What? You remember or you have a question?
I remember.
Oh, okay.
It's the Truth in Lending Act and the settlement statement combined together.
Correct. So as of October 3rd of 2015, they merged the Truth in Lending Act and the Real Estate Settlement Procedures Act, right, into what we call TRID. So instead of having multiple forms to disclose documents or numbers, right, they merge it all into one form, which in the beginning we call loan estimate, and at the end we call closing disclosure, CD. TRID requirements apply to most federal-related first and second mortgage used to buy residential property. So TRID only applies to purchases of residential property. It does not apply to HELOCs, mobile homes, reverse mortgages, cash transactions, or commercial loans. We covered all this in chapter 15. Remember, it's the boring part right at the end? We repeated like 3 times. In fact, here's what we repeated 3 times. Under TRID rules, the lender is required to provide a 5-page closing disclosure, at least, please underline, 3 business days before closing, with a minimum of 7 business days between the issuance of the loan estimate and the closing. You guys remember this? We repeated 3 times then. This is the 4th, and there's another one coming up. Just in case you guys don't remember. So now we have here in the next page, very important, a sample of the CD. Does anybody remember the LE, the loan estimate? The sample?
Yes,
Wasn't it very similar to this?
yes.
Okay, because the LE and the CD must be almost exactly alike. If there's any difference between them that would affect the loan, then it triggers a new 3 business day waiting period, because they have to adjust it. It says the property was sold for $180. The loan amount $162. Interest rate 3.875, and how much are they going to pay? $761. Mr. Homeowner, or I'm sorry, Mr. Potential Buyer, these numbers are very similar to what we had before. Are you okay with this? They say yes, we move forward. They say no, it needs to be adjusted, or we're not closing at all. It also says, closing costs. So if you don't know how to estimate, so as Louis, you're asking, how do we get this? The bank, through the LE, gave you this. You guys remember from LE? And now at closing, it's the updated. By the way, it's an extra $1,000. It could be, because I think the other one said 8,000 something, and here was 13,000 or something like that.
What page is it on? We'll check.
It doesn't matter right now. It's just to prove a point is that could be a small change, right? There's details that are discovered along the way. Does that make sense? So what you need to know is that the closing costs are $9,000, right? You already gave a deposit, so deposit is deducted from the down payment, right? So now the balance of the down payment plus the closing cost is $14,000. At closing, this is what you got to bring. Okay? And guys, do get familiar with this. It's not our job to prepare them, but we should be able to read. And I'll tell you why. If not for the customer, because we don't care about the customer. If not for the customer, I want you to go to H, section H. And I want you to go to line 5 and 6 and tell me what you see there. Mm-hmm. So if not for anything else, at least verify that your commission is correct. Bless you. And in case you guys do not know, I'm joking. It's not about your commission, it's make sure all the numbers are correct. Why? Because next page we have, right at the bottom. So it's page 305. The borrower must bring how much?
75.
No. 14,147.26. That's how much they got to bring. This is the summary of it. Look at the right-hand side. How much does the seller get? See, they sold for 180,000 minus all the closing costs, which are right here for them, so commissions and all that stuff, minus the balance of the loan. All that is 115,000. So how much does the seller get back? You got it? Questions? Good. Page 4, just additional information about the loan, if you can assume it or not, partial payments if they allow or not, and so on. On page 5, the last page, I love this page. You know why? Because you bought this house for 180,000, Mr. Buyer. At the end of 30 years, you're going to pay 285,000. That means the finance charge was 118, plus other fees, right? The APR was 4.175. The total interest you paid was 70% almost of the purchase. Of the loan amount, right? Because the loan was 162, 118 is what you paid in interest, so 69.46. If you guys don't remember, that is called tip. Thanks for tipping the bank. Good?
That's a 4%.
And that's a 4.
7%, 3 times purchase price.
Not 3 times. 6% is double. Anything above 9%, 8.5%, it becomes almost triple. But 6% is where it makes the double. And from there on, forget it. It's just ridiculous.
This is if you paid it off completely, right?
At the end, yeah, this is telling you that you got all the way to the end. This is how much you're going to pay.
You didn't make any extra payments and stuff.
Yeah, correct. Yeah, that's considering you didn't prepay.
This is
Yeah.
minimum payment. Yeah.
Yep. Same thing as your credit cards. They're now required to show you, if you just do minimum payments, it's going to take you 16.5 years, 16.4 years actually, that's the average, to pay off your $200 swipe. They're required to do so. Page 290. When the borrower receives the CD, they should compare the first 3 pages of the CD to the LE. We talked about this already. There should be no changes. I already went over the highlights of the CD, so just mark the bullet points. Just mark them. Mark the bullet points. And we're going to go to title procedure. Title procedure. Let's go to the bottom where it says the seller is usually required to execute a affidavit of title, and this is a sworn statement in which the seller assures the title company and the buyer that since the date of the title examination, there has been no judgments, bankruptcies, or divorces involving the seller, that no repairs or improvements that have not been paid for, and that he or she is in possession of the premises. So this affidavit is me swearing and subscribing, right? So signing it off under penalty of perjury that everything that I've been telling you is true. But if it's not true, It says that through this affidavit, the title company obtains the right to sue the seller if, again, this is not true. So if there's any issue that shows up in the future, who's responsible for it?
So,
The seller. Simple. On top, checking the premises. Question, should we inspect the property?
Yes.
Great, I like the first sentence. Last sentence, should we re-inspect the property right before closing?
Yes.
Absolutely. A final walkthrough, guys, it's your responsibility, realtors, to schedule the final walkthrough. The client does not waive the final walkthrough if they don't know about it. So you have to tell the buyer, hey, let's schedule a final walkthrough. If they say no, don't worry about it, that's on them, not my monkey anymore. Right? I tried to schedule. You said no. But it's our job to make sure that they go through. Why? Because in the final walkthrough, when everything is clean, supposedly, this is when you get to see all the details of the property. Okay? Just like a rental, after the tenant leaves is when you see the big manhole that was behind
The coach.
the, I was gonna say like something taller than the couch. This manhole behind the couch.
Bookshelf?
Ah, bookshelf. We'll go with that. All right. Next. Releasing existing liens. Quick question. If there's a lien, that means there's a money or financial claim, yes? Great. So how do we release a financial claim?
Gotta pay it off.
Gotta pay it off. So what do we get to release an existing lien? It's in green right here. We get a payoff statement. So if there's liens against the property, what we must do is call every single one of them and say, hey, I need a payoff statement for a closing that's gonna happen in X amount of days. And they'll give you a letter that says, this is what you need to pay off, including interest, penalties, or any other fees, and it's valid until such date. Beyond that date, please account for, let's say, 1 point whatever % per day. You guys got it? So this is done for every single lien that's against the property. We have to pay it off at closing. Any questions on this? Simple so far? Well, this is simple, pay it off.
any questions?
No.
Sure.
Oh, you were gonna say it's gonna get complicated.
Oh, it will. That's why I said simple so far.
Go north to south.
Yeah. I'm not even counting. She's already spinning on this. I'm asking the rest of you. You know why I say spinning, right? Have you seen a compass where it doesn't know where north south is and that thing just... Has anybody been to school before where you had these experiments? No? Okay. Don't look at me like that. Closing and escrow. Before you guys highlight or write anything, what is escrow? I didn't say escrow account. I said escrow. So before you say trust account. Sorry?
Okay, the big deposit.
Nope. Escrow. The word escrow.
Reserve.
Almost.
Holding.
Holding. Okay, we're getting there. Anybody else? I'm sorry? Escrow is minus. It could be a plus. Depends.
Retainer.
No. You guys are still thinking about money. I didn't say account. I said escrow.
Something put aside?
Something put aside. Holding. Something put aside. Third party. Not related. Okay? Every time we put something in escrow, we are either reserving or holding or putting aside something. Okay? In this case, closing in escrow is where both parties put documents with a third party, disinterested third party. So I'm not holding it, you're not holding it, we put aside.
Trust account.
The trust account is for monies. In this case, a title company is the escrow agent. You got it?
Yeah.
An attorney could be an escrow agent. But the key thing is that it's a disinterested third party that collects those documents. So closing in escrow is literally buyer and seller, right here, deposit all pertinent documents and other items, including monies, right, with the escrow agent, with a third party. So every time you see escrow, third party, because an escrow account is to hold other people's money. So it's a third party. You guys got it? Think of escrow as third party, not related to you, always setting aside. So
I bet you Giants are gonna win. You
bet Giants are
me
gonna
the Jets are gonna win. $100, he escrow our money. Whoever wins.
But that's account.
That's the escrow guy.
Account, yes. Well, this is escrow in general.
It's probably easier to
But
explain.
between Giants and Jets, we're screwed on this bet.
Of course. Regardless.
But yes.
Just an idea, right? I bet you, you bet me.
Yeah.
So.
So we'll put with somebody else to hold. But in this case,
But it has to be trusted. This guy might not.
it has to be trusted, yes. So, but it's not only about money. It's not only about money. That's what I was, guys, it's not, what I was trying to say is that escrow is not only about money. Escrow just means third party. So like Paul was saying, you put it with somebody else. Your documents that belong to me, belong to you, we put it with somebody else. If it's money, in the case of a bet, he becomes the escrow agent handling the money. In this case, it's foreclosing. It could be money and all other documents. And hopefully the Giants and Jets are not involved.
Well, one day.
Well, we can only hope.
And lose your whole.
Next. When everything has been met, right? So we're done with the game. Everything has been met. The escrow agent is now going to release the monies and record the deeds. Right, Louis?
I'll try.
He already wasted all the money. He knew neither one was going to win, so he wins. So whoever's watching from home and guys here, if you're a Giants or a Jets fan, I'm just joking, okay? I don't want to get sued.
Are you?
That was just your personal opinion.
Personal opinion, that's it. What?
Still in New Jersey.
You're a Giants or Jets fan?
Yeah, New Jersey, not talking about no way and stuff.
Well, there's a lot of people in New Jersey that were, following, was the 49ers? All right, preparation of closing statements. Manchester and Barcelona, that's it? Can you get out of my class, please? Did you say Barcelona? Really?
Real Madrid lost this one.
I'm sorry?
Real Madrid, they lost this one.
They did. That doesn't mean anything.
And why Barcelona?
Everybody loses. Imagine having a perfect record. That would be awesome.
Another rule to real estate, do not discuss with your clients any sports, religious,
Or
beliefs,
politics.
anything like that, or politics. Stay away from that.
Yeah.
You
That's
lose
why
your
I'm
listing.
discussing with
You
the
lose your listing
students.
when you're closing, trust me.
Or, as I always say, keep it out of your social media as well. Make it easier. Next, preparation of closing statements. A typical real estate sales transaction involves numerous expenses for both parties in addition to the purchase price. There's a number of property expenses that the seller pays in advance for a set period of time, or that the buyer pays in the future. The financial responsibility for these items must be prorated. The word prorated means adjusted proportionally or accordingly. Now, this is adjusted between the buyer and the seller. At the bottom. We're going to go over that in a second, so for now, just skip to the bottom. Closing statements are prepared by the buyers and sellers attorneys, title officers, or bank representatives. I find it funny how I say Barcelona and Victor goes like, oh, Real Madrid lost too. Who said my favorite was Real Madrid?
Because if you're talking about Barcelona, obviously you're a Madrid fan.
Could be the other one. There's another Madrid with a
Okay,
great
Real
coach.
Madrid.
Oh, okay.
Am I
Still,
right? Am I right then?
no, maybe.
Ah,
That's the first thing. Like Barcelona, okay, you're Real Madrid. Has to be.
yeah, if you're talking about Barcelona.
All
teams
the
don't
all
talk
the
about
other
Barcelona.
teams don't like Barcelona. So what do you mean, just Real Madrid?
Nobody likes you.
Next, closing statements are prepared by buyers and sellers attorneys, title officers, or bank representatives. Does it say? Does it say realtors, salespersons, brokers? Is that what it says? No. Who prepares the closing statements? Attorneys, title officers, or the bank? But it says right here that the brokers should, however, possess the necessary knowledge to prepare statements so as to give the seller an accurate estimate of sales costs. In addition, the buyer must be prepared with the proper amount of money, we're just repeating things, to complete the purchase. And again, the broker, us, because we represent the broker, us, should be able to assist in making a reasonably accurate estimate. Obviously, that's going to go, it's going to go with experience, right? But here's how the closing statement works. They have a better idea. The completion of a closing statement involves an accounting of the parties' debits and credits. First thing is debit. A debit is a minus. It's a charge. Something that's taken away from you, right? So debit is a charge, an amount that the party debited owes, right? And on top, and must pay at the closing. Now, a credit is a plus, an amount entered in the person's favor, either an amount that the party has already paid, an amount that the party must be reimbursed for, or an amount that the buyer promises to pay in the form of a loan. So debits and credits. If you look at your checking account, there's pluses and minuses. Minuses is what everybody takes. Pluses is the only thing you put in your paycheck. Does that make sense? So every time you deposit, plus. Every time you swipe a card, minus. For closings, we need to determine the amount that the buyer needs at closing, and the debits are totaled. Any expenses and parade items, which we're going to go over in a second, for items prepaid by the seller are added to the purchase price. Then the buyer's credits are totaled. And these will include the earnest money. What is a credit? It's a plus, right? So if you already paid, you deposit, good faith deposit, right? It's a plus at closing, right? And the balance of the loan, the buyer's obtaining or assuming, and the seller's share of any prorated items that the buyer will pay in the future. Again, I'll explain that part in a second. Finally, the total of the buyer's credits is subtracted from the total amount that the buyer owes, and to arrive at the actual amount of cash that the buyer must bring to closing. We're good so far with this? All right, it's just literally telling you, you're going to figure out what they need to bring at closing based on closing costs, the deposit that they already put in, and the balance of the loan, which is the down payment. You guys got it? That's pretty much it. There's another variable, which is prepayments made by the seller. We're going to go over that in a second, that if we close in February, but the seller prepaid the whole year's worth of taxes, then you are responsible for crediting the seller that difference, because you're the one that's going to take advantage. Does that make sense? Yeah. So that's the variable there. Now, the buyer usually brings a bank's cashier's check or certified personal check, not a duffel bag full of money. Long are the days. Don't tell me that's what your buyers do. Oh, you do it, okay. It says the buyer, so the realtor is excused from this law. Now, a similar procedure is followed to determine how much money the seller actually receives. The seller's debits and credits are each totaled. The credits would include the purchase price plus the buyer's share of any prorated items that the seller has prepaid. The seller debits would include expenses, the seller's share of prorated items that to be paid later by the buyer, and the balance of any mortgage loan or other lien that the seller is paying off. Finally, the total of the seller's charges is subtracted from the total credits to arrive at the amount that the seller will receive. Again, pluses and minus accordingly. So a plus is what you're getting paid for the property. A minus is got to pay off the loan, got to pay off the water, got to pay off this, got to pay off that, right? Those are minuses, and then you figure out how much to take home. So the good news is that we don't calculate this. Again, the bad news, you should be able to estimate an average of it. So now in the next page and a half, we're going to go over expenses and who pays what. It's very simple. We're just figuring out who pays what. So who pays the broker's commission? Without reading. Really?
Who agreed with
Who did chapter 3 with me? Margarita, could you give me that answer again?
who agreed with
She said it under her breath. Whoever agreed with it. I got it. Whoever agreed to pay. That was chapter 3. Agency is not created based on who pays the commission. You got it? So the seller, most of the times, is the one that agrees to pay. Right? But it could be the buyer. If you're represented by the buyer only. You guys got it? Next, attorney fees. Who pays the attorney fees?
Buyer.
Either or. As a seller, I pay my attorney. As a buyer, you pay your attorney.
And some sellers will agree to pay the buyer's attorney, just.
Some sellers will agree to pay everything,
Exactly.
depending on how desperate they are. Just, can you please buy my house? I'll pay for everything.
Pay the first month mortgage.
You know what? Your first years of mortgage will be paid as well. I really need this divorce. Now, recording expenses. The seller usually pays for recording charges or filing fees that are necessary to clear all defects and furnish the purchaser with clear title in accordance with the terms of the contract. The purchaser pays the recording charges incident to the actual transfer of title. So let me explain this real quick. Today is the closing date. Okay? We're all happy, money. For the seller, anything prior to the closing date, they are responsible for paying to release that mortgage or any other liens and recording of satisfactions. Yes? From today on, from closing date on, the new deed, the new mortgage, anything else from day on, who pays? The buyer. So that's what we just read. The seller pays for whatever is needed to release from public records, right, until this day. From this day on is the buyer. Very good. Louis, we were talking about this. Transfer tax. Every closing in New Jersey must report a realty transfer fee and must be charged a realty transfer fee in every transaction. Now, we can estimate this based on the table that's presented, table 21, 1. Don't worry too much about this right now, but it is very clear based on sales price how much you're going to pay in transfer. Okay? So once you get experienced enough, it should be easy for you. Hey, it's up to 150,000, so you're going to pay $2 for every 500. That's it. And it gives you an idea of what they have to come up with at closing, just for that. Title expenses. Who's responsible to pull title? The buyer, right? So who do you think is responsible for the title search?
Buyer.
The buyer. That's what it says. I like the first two sentences because it says buyer. Now at the bottom says, in some areas the seller pays for the initial search and the purchaser pays for the redate charge. Elsewhere, the buyer pays for the full search. So what we're saying is simple. Remember what I said before, that you should have your seller do a title search before? Okay, it is possible. And then the buyer would pay for the redate charge. In some areas, it's like that. Seller pays for the initial, buyer pays for the final. In New Jersey, most of New Jersey is the same way, which is buyer pays, period. Okay? Loan fees. Who's acquiring the loan? So who pays for the loan fees? Simple. Highlight first sentence. See, this is easy, right? So far. Tax reserves and insurance reserves. Who's buying the house? Who has to put money aside just in case? The buyer. What is a reserve? Money aside. Or escrow, stuff that's get put aside just in case. In the event of. Are we good so far? Great. Additional mortgage related fees. Again, who's getting the mortgage? So who pays for additional like MIPs and PMIs? The buyer. Appraisal fees. Who pays for the appraisal? Either or. Either or. But if there's a mortgage, traditionally the mortgage company charges the buyer that fee. Because the mortgage company will not issue a loan unless they appraise the property. You guys got it? But either the seller or the buyer could get the charge for the appraisal fee. Sometimes what? Yeah. Survey fees. Survey says? Buyer. Because a survey will be required by the mortgage company. They want to make sure they are funding the purchase of the right parcel of land and nobody else has rights to your parcel. Right? We went over this in deeds and stuff, right?
Why do mortgage company allow them to waive that?
Sorry?
Why do mortgage company allow them to waive the survey?
So if it's less than, so it actually says right here, no, it doesn't say much, but if the seller has a survey that was done less than 10 years ago, they'll just review it and they will not resurvey the property. If it's in an area where a sale occurred not too long ago as well, like it's a new owner, then it's clear. It was clear before, it should be clear now. In certain areas, they won't. Because that's what I just said, the high turnover. Or they ask the attorneys. The attorney asks, is there a survey? You should ask, do you have a survey at the time of listing? Do we ask if we have surveys? You do? Great, because most realtors don't ask anything. They just ask, please sign right here and I'll come back later.
And how much are you willing to pay?
No, sign, that's it. Some don't even ask how much you're willing to pay. They just put the fee right away. Unfortunately. Prorations. Did I tell you what a proration was? Adjustment, right? Proration is because there's money that the seller prepaid or that the seller owes. And it needs to be prorated and fairly divided between the seller and the buyer. So, it says right here at the bottom, interest. I just want to address interest real quick and then we'll go into other examples. But it says right here at the bottom that interest is usually paid in arrears. Because interest, you only pay for the time that you have used. So 30 days go by, you're paying interest for the last month. Just like your credit cards, right? They close the statement based on the month that just passed, right? So if you have a mid-month closing, it says right here, the seller who has not made the current month payment might owe 6 weeks back interest on the mortgage. Good so far? Okay. Now, accrued items. Accrued items are items to be prorated, such as water bills and interest on assumed mortgage. They are owed by the seller, but eventually will be paid by the buyer. The seller therefore gives the buyer credit for these items at closing. So where it says accrued, I want you guys to write unpaid. Unpaid. Because the next one is prepaid. So accrued is unpaid bills. Prepaid items are items to be prorated as well, such as taxes or fuel oil left in the tank. that have been prepaid by the seller but not fully earned or not fully used up. They are therefore credits to the seller. Okay? Good? I'm going to address this in a second. Right now we're just highlighting. General rules for prorating. The rules or customs governing the computation of prorations for the closing real estate vary. It is generally provided that the buyer owns the property on the closing date. Yes?
Yes.
We close, the property is mine. The question is, did we close in the morning or did we close in the evening? If we close in the morning, is the buyer liable for that day's expenses? If we close in the morning, you took over. If we close in the evening, the seller is responsible for the whole day because I still used one day. So in practice, however, either buyer or seller may be charged with that day. Right? Because if we close in the morning, is the seller liable for any expense for that day? No. So it goes on the buyer. Next, mortgage interest, general real estate taxes, water taxes, and similar expenses are computed in some areas by using 360 days in the year and 30 days in the month. Do you guys remember this? We talked about accounting weeks and accounting months and accounting years. 12 months, 30 days. But we know that there's really 13 months. It's just that the extra month is divided in the calendar by extra week here or there, extra days here or there, right? Great. So that's why it says, however, the rules in other areas provide for computing prorations on the basis of the actual number of days in the calendar month of closing. So there's the accounting and there's the calendar. Depending on what you're accounting for, we either use, bless you, we either use the 30 days or the actual calendar days. Special assessments. Does anybody remember special assessments or improvement taxes? Okay, I love the yes. Can anybody tell me what it
When the
is?
city improves like the roads or
Perfect.
schools or that kind of stuff.
Absolutely. Anything that the city does that will improve or benefit your property, it's a special assessment. So it's an add-on tax. It's separate from the ad valorem or general tax. Now, because these are larger charges, they don't put onto your property and have to be paid in full the 1 year. Most of the times, there's annual installments over several years. Now, the sellers are sometimes required to pay off the special assessments, right? In other cases, the buyer may agree to assume the future installments. Everything's negotiation. Rents. Now, the rent is traditionally monthly, right?
Yeah.
So, rents are usually adjusted based on the actual number of days in the month of closing. So, for instance, if we close on the 16th of, we're in February, so if we close on the 16th, how many days we have this month? 29, right?
29.
This year's 29, right? That's why I asked this month versus the regular. So that means there's how many days left?
14,
If we're on the 16th, there's 13 days. Now, the rent is $1,000. I'm not going to make you do math right now. The point was, the rent is $1,000. If the seller collected the rent of $1,000, right, but we're closing on the 16th, then the seller owes the buyer 13 days. So we would have to divide the $1,000 by the 28 days, right? 29 days times 13 days. And that's what we're saying here. It's based on the actual number of days of closing. What if it was uncollected and the buyer now receives the money?
Yeah, so pay that seller.
You got it? For the 16 days. So that is calculated based on the actual number of days. Next, security deposits. Security deposits. Who do they belong to?
The buyer transferred to the buyer.
Who do they belong to? That was my question.
The-
They belong to the tenant.
Yeah.
So can the seller keep it?
No.
No, has to transfer to the buyer and notify the tenant of that deposit.
And like
Okay.
Ken said, make sure it's transferred or you still owe.
Make sure it's transferred or you're still liable. Yep. Like cocaine said, love it.
Just be in the bearing account. All the
Huh?
money.
The interest bearing account, yep. Not just the bearing account, interest bearing. We're almost done. You guys can see it, right? Did we get to that page? Because I cannot see on my screen. Does it say on the right-hand side?
Yes.
Okay, so let me make sure. So we're gonna slow down because we still got 14 minutes to go. Accounting for credits and charges. All right, so the items that must be accounted for in the closing statement fall into two general categories. And we have prorations or other amounts due to either the buyer or seller, these are credits, and paid for by the other party, debits. And the other category is expenses. Expenses are debits only, something that that party must pay for, period. They don't get reimbursed, it's a payment. So this is what I want you guys to do. You're gonna do a table. We're gonna play tic-tac-toe for a second. Ready? In this table, you're gonna write buyer, because usually the borrower goes on the, for some reason, I don't know why, but borrower goes on this side and seller goes on the other side. So, seller. The only reason why I don't understand is because you sell first in order to buy. So it should be seller and then buyer, but they have it reversed. And then when you're gonna write here on the side, you're gonna write, I'm sorry?
The buyers.
The seller receives after.
The seller gives.
And the buyer gives, the seller receives. Right?
Let's go.
The buyer gives the money and the seller receives the money.
Talking about the 100.
Yeah, buyer gives, seller receives.
Unpaid taxes. Oh, I'm sorry, don't write that, don't write that. It's prepaid. In my example, sorry, prepaid taxes. And then unpaid water. And then attorney. Okay. So my question is this. There's prepaid taxes. Like I said, we're closing somewhere in February and the seller prepaid the whole year already. Okay? If the seller prepaid, should they get credited for that?
Yes.
All right. So that is a plus, right? Now let's say what they have to get paid, prorating, right? Adjusting, what they have to get paid is, let's say, $10,000. So let's assume, to make it simple, it's $12,000 for the year. If we're closing at the end of February, right, the seller gets back the remaining 10 months, so $1,000 a month, $10,000. What about the buyer?
Well, he has to.
He has to pay what?
Instead of a date.
Say it again.
He has to pay somebody.
Because it's prepaid by the seller, and the buyer is going to take advantage of it, they're going to benefit for the remaining of the years, the buyer has to pay the seller that money. So it's taken from the buyer, given to the seller. The reason why I'm doing this is very simple. Because you guys spend a lot of time calculating how much money it is. You're trying to figure out the $10,000 out of the 12 months, $12,000, you're trying to figure out the 10. In this scenario, it was easy. But if they tell you the yearly taxes are $9,310, now you have to divide by the 12. Now you have to multiply by whatever it is. Don't. I'm going to show you a simple way. You don't even need a calculator for this one. For this answer, you don't need a calculator at all. You're going to need roughly 1 minute of just understanding the question, looking at the answers, and ruling out the answers. Okay? If it's unpaid, and let's say that the seller had to pay $600 in the water bill, who's gonna have to pay for that?
Seller.
No, no, wait, but who's gonna have to pay for that after closing?
The buyer.
The buyer, right? So that means that the seller is deducted the $600, and the buyer, because they're gonna be responsible for it, they get a plus of $600. We good so far?
Yeah.
Great. What about attorney fees?
Both.
Both what?
Agreement.
Each one pays their own, okay? See, but traditionally, each one pays their own. So minus 1,200, and here, minus 1,800. I'm just saying, it's whatever you agreed with your attorney. Some attorneys charge more, some charge less, so that's why I'm putting random numbers, so you guys see the difference. You guys notice that the prorated ones are exactly the same. The expenses only, it depends on whatever your expense is. Is this good so far? Okay. Here's the rule that you need to follow when you look at the answers. There's 4 answers, right? And random stuff. If you see prepaid, means that the seller gets credited. So you're going to look at the answer that says credit to the seller. If there's 2, you just ruled out 2. Got it? Then the other thing you're going to look at is going to be the fact that these amounts are exactly the same. So there's only 2 answers that say credit to the seller, but only 1 answer has exact amounts. You got it? It'll say credit to the seller, I don't know, $10,000, and debit to the buyer $10,000. That's the correct answer. One of the answers might say debit to the seller, debit to the buyer. Unless it's attorney fees or expenses that they incur, it's wrong. You guys got it? If it's unpaid, the credit is to who?
The buyer.
The buyer. So you're going to look for the answer or answers that say credit to the buyer. You guys got it? And then equal amounts. There's only one that matches this. Do we need to figure out how much went to each one of them? No. We just need to look for who gets credited and then equal amount. That's the answer. Who gets credited? If it's unpaid, seller. If it's prepaid, buyer. You got it? Equal amounts. Simple as that. And the answer is D.
Yeah, it's the,
Anyway,
it's D1, D1.
it's D1. Yeah, let's go with that because we're live. It's D1. You guys got this? Simple enough? Do we need to use a calculator for this one?
No.
So there's up to 8 math questions. And roughly 3 of them do not need calculators, just common sense. This is one of them. You got it? Well, I hope I helped with this one to be common. Okay? All right. You sure no questions on that? Great. Because here's the thing. Items credited to the buyer. So to have an idea of stuff that the buyer might get, and it's debited from the seller, I mean taken away from the seller, given to the buyer. It's unpaid principal balance of the outstanding mortgage being assumed by the buyer. Interest on the existing assumed mortgage not yet paid. The buyer's earnest money. Rent collected. And so on. So it gives you a pretty good idea of stuff that the buyer would get, with the majority of them being taken from the seller. Now it's the opposite. Credits to the seller. Obviously, the sales price is a credit to the seller, minus everything else, but it's a plus to the seller. Prepaid items, credit to the seller. You guys got it? Most of them debited to the buyer, and so on. Good? That's it. Just mark the bullet points. And let's go right-hand side on top. And I already explained this. If it's expense, it's debits only. If it's an expense, it's debits only. Good? Next. Arithmetic of prorations. I don't come up with these words, okay? Arithmetic of prorations. All you need to remember is to highlight exactly as it is here. And then when we get to the math chapter, I'm going to give you guys a weekend to relax, recharge, and prepare for math on Monday. When we get to the math chapter, we'll go over this in detail. There's a reason why I'm telling you guys to highlight exactly as it is here. Because number 1 starts with a yearly charge. And number 3 starts with the yearly charge. The reason why I highlighted this way is to show you that number 1, the yearly charge is divided by 360, or 12 months of 30 days each. The monthly charge is divided by the actual number of days in the month, like rentals, right? And then the daily charge is the yearly charge divided by the calendar days, 365, and then multiplied by that. So 3 different ways to calculate. If you guys don't know what to do, don't worry. Final proration figure varies slightly. So depending on which computation method you use, you can pretty much predict what you've done wrong. Okay? What'd you say?
Don't get it, just get lost.
Yeah. Just skip. Just skip. That's what it is. All right, wait, closing? Can't do this. Can't close. Here's what I want you to know. This is the traditional transactions. Nowadays, title companies prepare all this, but traditional transactions, the way it works is the seller's attorney is responsible for all the details of the transaction that concern title to the property, such as preparing the deed and making sure any prior liens have been repaid. So the seller's attorney prepares all this. The buyer attorney prepares the actual settlement statements, so the closing, right? And makes necessary disbursements of the buyer's checks, meaning the buyer's attorney is the one that pays everybody off. That's traditional transactions. Nowadays, we tend to close in escrow, where the title company handles all of this and pays everybody out. Good? It is usually the broker's responsibility to ensure that the parties appear at the designated time and place with the appropriate documents, and that arrangements have been made for any special factors, such as measurement of the seller's existing supply of heating fuel. I just want to point something out real quick. It said here that it's usually the broker's responsibility to make sure everybody knows where they're going. Because if the seller does not show up at the closing table, are we closing?
Nope.
If the buyer does not show up at the closing table, are we closing?
Nope.
No. So do you guys remember that throughout 21 chapters, I've been telling you, client first, client first, client first? Great. This is the only time I tell you, you first. You're going to call the other realtor, you're going to call the other attorney, you're going to call everybody to make sure everybody understands. So closing is at 18 Oliver Street at Suite 301, yes? If everybody's in agreement, that's where it is. It has happened to me as well. Again, I can tell you a bunch of stories, and I'm pretty sure you guys have had these stories as well. It has happened to me where the buyer's agent says, no, the closing is going to happen over there. I'm like, no, closing is going to happen here. Here's the email. No, I spoke. No, not happening. So even realtors sometimes are not in agreement of where the closing is going to happen. At that point, what do? We call everybody and figure out where it's happening. Because if the realtor, called the title company, or the closing agent, which could be the buyer's attorney, but if the realtor, no, but here's the thing, if the realtor is saying it's somewhere else, then they're going to instruct their buyer to go somewhere else, or their seller to go somewhere else. Are we closing?
No.
No. So this is the only time that it's you, and you. Why? Because normally, the broker collects his or her commission at closing. At this point, you've done your job. So one last time, make sure everybody follows your lead. Where are we closing? Make sure everybody knows where it is. Is this good at your house? Is this good? Great. Final thing, and I'll kick you guys out of here, is this. Every real estate sale must be reported to IRS by one of the following: the person conducting the closing, seller's attorney, buyer's attorney, title company, or the real estate broker. It's just something to remember. It has to be reported to the IRS. Any transaction of $10,000 or more, or value of $10,000 or more, must be reported to the IRS. We remember this, right? Are we good?
Excelente.
We made money? Great.
Only at the closing.
Only at, well, this was the closing. So, guys, have a good weekend. Make sure you review everything. And Monday, it's math. So, make sure you bring calculators. Okay? Make sure you bring calculators. Not your phones. Calculators. And when I say calculator, it's a POS calculator. Does anybody know what POS stands for? You can't say plain old simple? It's a plain old simple calculator. The cheapest calculator you can find. Go to the Dollar Tree or the Dollar General, and it's $1 plus tax. Okay? Get the big ones, not the small ones. You guys good?
Yes.
Have a good weekend. Not